Hello, thank you for joining us for the H-1B overview, the compliance seminar. I'm sure many of you are getting ready to eagerly waiting for the H-1B, the notification of how many of your H's got selected for the cap this year. I have to tell you that it is much better this year than it has been in years past. In that before, back in the day, and that's going to date me, but we would have to literally file all the H-1Bs before, we even knew whether they would be selected for the cap. This way, it's so much easier. Law firms, companies don't have to expend additional on, legal fees in order to do this, so it works out well. But in addition to our immigration services, I do a lot of compliance. I represented the state of Virginia for about a decade, assisting the state, making sure that they were compliant with their immigration obligations. And I represent a lot of companies in immigration audits, and we just finished up one. And so I can give you some insights as to what you need to do to stay compliant. So let's begin. We'll have Q&A at the end. So we're going to kind of go over the I-9 compliance, common documentation, the H-1B compliance, and some recruitment strategies. I often do an advanced HR seminar at the University of Richmond for advanced HR representatives that do a lot of international work, and they've always found this to be a very helpful seminar. So, number one, the employer responsibilities under the I-9 regs. Now, the I-9 regs came out during the Clinton administration pursuant to IRA Act. And what it created was a way in which employers could verify the employees' work documentation. It's a very simple process. The problem is it's like walking on a tightrope. And that's why you have to follow, the guidelines very clearly, because if you kind of go a little overboard, then you could be accused of national origin discrimination. Underboard, you could be hiring someone without authorization to work. So the I-9 is used to verify identity and employment, and it includes, you have to do that for everyone. The process has to be the same, but you cannot ask, and you can only go through this process after there's a formal hire, offer, and acceptance. You can't do that before you hire an individual, because again, that would raise all sorts of national origin issues. Now, you can't request specific documentation. There is a list, you present the list, and I know that's where it gets tricky, because often the person that's supposed to be completing out, they don't know what documentation to file. But it's really very, very simple. You have list A, which provides both identity and employment verification. And then you have the lists B and C documents, where one provides identity and one provides employment verification. So if you don't have a list A document, they have to give you a combination of list B and C, but you cannot request specific documentation from them. And so let's go over some of the documents just so you're familiar. And remember, they don't expect HR representatives to be USCIS specialists in reviewing documents. If on the face of the document it looks valid, then that's all you need. So you, of course, there is the visa. The visa does not control a person's ability to stay in the United States. A visa is just an entry document. And there's certain things on the visa. For example, the type of non-immigrant classification. Literally, you've heard of permanent residents or green card holders. The green card process is a pretty long process if you're from India and China. It takes about 12 years. So individuals usually come into the United States on temporary visas or non-immigrant visas. And those visas are valid for a specific period of time. So it's literally an ABC list. So each classification has its validity period, has its restrictions, and has terms and conditions. So the visa type, you can only enter the United States. A person may have multiple visas in their passport, but you can only enter the United States on one non-immigrant status. And so the visa documentation often shows you what that status is. The second type of documentation that's often seen is it's a 9797 notice of action. And it just says that the USCIS has done some action on that particular petition. There is the receipt date, the name of the individual, the type of filing, the type of notice, whether it's a receipt notice, approval notice, and the validity period. The I-797 is usually the approval notice that is issued in the United States when a petition is filed in the US. So a person can either choose to extend their status in the US, change their status in the US, or you can file for a foreign national who's not in the US currently, but abroad. So when you get an approval notice for that individual, it'll look similar to this. If you're filing an approval notice for someone who is already in the United States, on the bottom of the approval notice will be an I94 card. The I94 card is what is critical for their lawful status in the US. Now, the I94 card is either issued, like I said, on the bottom of the I-797, and this is what it looks like. It will have the name and the date of birth, the country of citizenship, and a lot of people get confused because they were born in one country, but they have a citizenship of another. The USCIS will always put down the country of birth. And it'll have the expiration, the type of visa. You can also get an I-94 card when an individual enters the US. And at CBP inspects their documents and they issue an electronic I-94 card. One tip that I tell HR, which is really hard to do, but you need to keep track of when your H-1Bs or any of your foreign national resources enter the United States. Because a lot of times what they will do is, because it's issued electronically, they never look at it unless it's time for their extension. If there's a mistake, the CBP is notorious for making mistakes on the I-94 card. Even if it's a mistake, that I-94 card is, is the card that denotes when, how long they can stay in the US. We had a situation where the CBP shortcut the person by at least 1 year. That's horrific, because then they're subject to the bars. So in that instance, it was through Atlanta, we were able to have them go back to Atlanta and get them to reissue the I-94 card. But that is very rare. If it's too long, they don't like to reissue it. So as a practice pointer, I would suggest that, HR typically, if you know your resources traveling, have them as a pattern in practice, send you a copy of their electric I-94 card when they re-enter. Another type of common documentation for I-9 purposes is the employment authorization document. Now, the employment authorization document can be used by a number of non-immigrant classifications. If you have an F1 who is on optional practical training, the 1 year that they're able to work in the United States in the area of their discipline, then they would get an I-94 card. If a person has filed an adjustment of status on their path to become a permanent resident, they may get an employment authorization document. Sometimes dependents, whether they're H4, L2s, or Es, are also entitled to obtain employment authorization documents. So how do you know what category? The category is listed on the card as I've indicated under C9. And if you Google employment authorization documentation categories, it'll give you a list and let you know. So that just on the face of it, you can make sure that when they fill out the I-94 card and they're saying that their adjustment of status, sometimes they'll have an adjustment of status, EAD, and also an EAD for their H4 or L2 status, that they're giving you the right one that is they've indicated what, pursuant to the status that they've noted. Another documentation that you may see often is the green card, which is no longer green. Now, when a person receives the actual card, it will look like this, and it'll have an expiration date. So there's a little nuance with I-9 with expiration date. The card, their status doesn't expire. So it's only that the card expires. So you're not required to re-I-9 them or put a tickler as you would for other temporary statuses where, there's a validity period. And at the end of the validity period, you'd have a tickler or some kind of, way in which you're able to, and I will take all questions at the end, I promise, that you're able to, respond to making sure they're re-I-9'd once their status is expired. Now, another nuance to status expiration is there's something called the 240-day rule. That's not within the USCIS regulations, that's within the I-9 regulations. If a person files an extension of status while they're still in valid status, while that petition, the extension is pending, they have the authorization to work for 240 days. And so for the I-9 purpose, what you would do is you'd have their previous approval notice, and then you would use the receipt for their extension to allow for the 240-day, their ability to reside in the United States for 200 or work in the United States for 240 days. But after the 240 days and with lengthy adjudications, that's all you get. But with extensions, you can, as I'll talk about in a minute, you can always apply for premium processing for the most part, if it seems like you're running up against that deadline. So back to green cards. So green cards are either issued with a card, or if someone obtained their green card overseas and enters the United States, at the port of entry, they're issued what's called a 551 stamp. And the 551 stamp gives them the ability to travel and work in the United States for up to 1 year. And the validity period is stamped on the card while the USCIS issues the actual card in the mail. So now let's move on to the main focus of our discussion. And for any of you that would like a copy of our handbook, we'll be happy, just email us at info@cellolaw.com, and we would be happy to send that to you for your, so you can use it as a reference. So this is a process for an H-1B for any of you that are new. You're dealing with 3 agencies. Really, if the foreign national is in the United States for the time being, 2, the Department of Labor, the USCIS, and then if they have to travel outside the US, the Department of State. So DOL, their job is to make sure in the H-1B realm that there's no US workers, that we're not displacing US workers with cheap labor force. It's a crazy notion because any of you that is in the recruitment realm, as part of your HR duties knows that we're at a scarcity of resources now. So that's certainly not the case. But that's their wheelhouse. It is wages. It is making sure US workers are not displaced. And then you have the USCIS. USCIS wants to know, their purview is this an H-1B eligible position? Does the individual foreign national have the qualifications of an H-1B? Is there sufficiency of work? So these are the things the USCIS will review. So how the process works is you first file what's called a labor condition application with the Department of Labor. It's an electronic filing. It usually takes 7 days for certification. But if you are new and you've never filed an H-1B as a company before, it will take up to 10 days so that they verify it. It is geographic location specific. because there are salaries and wages that are attached to the Department of Labor. The employer has to pay the minimum of at least the prevailing wage or the actual wage. The actual wage is the wage you pay employees with same or similar job duties. And I'll explain that in a minute. Once you get the certification, you're ready to file with the USCIS. With the USCIS, the documents gathered are information about the company, usually financials, any background about what type of work they do. And then, if they've got a handbook, if they've got something to demonstrate the type of work the employee will be doing at the employer with the employer. And if they're placed at a third-party site, you're going to have to show that the employer has the ability to control the employee's work. That's not the case if it's traditional employment and the employee is working at the petitioner's job site, but it's only if they're working at a third-party site. Now, as I told you, you don't need a visa to reside in the United States. So if you have a student that's changing to an H-1B, it's okay if they don't have an H-1B visa, but you just need to know that when they go to process their visa, that they will need to get a new visa to re-enter the United States. And that's run through the Department of State. Now, the validity of an H-1B. An H-1B is valid for 3 years, and it's issued in 3-year increments. It can be valid beyond the 3 years as long as your foreign national is far enough along in your H-1 in their permanent residence process. So it's really important that you keep an eye on these dates. I know we do, so that if you know that it takes about 1.5 years for the foreign national to get to that place where they can extend beyond the 6 years, then, it's important that they start that green card process early on. The fees associated with the H-1B, the DOL has no filing fees. The USCIS has several fees. There's the fees for the actual form filing. There's the employer fee. It depends on the size. $750 for 1 to 25, and over 20, from 26 onwards, it's $1,500. There is the fraud fee of $500, and there's premium processing, ability to expedite the processing within 15 days if a person goes beyond the 6 years. And there may be, these fees may be old, so Ashley may, oh, the slides aren't changing on your end? Okay. You cannot see the PowerPoint. Let me see what happened with that. Thank you for telling me. I don't know why. I see the slides changing. Let me do, hold on. Stop share and share it again. Can you see it? Can you see them now? Okay, good, good. Let me know if you can see them advance. And Ashley, chime in if these, I think these fees are correct for right now, but I know that they keep increasing their fees. That's one thing. The process has gotten slower, but the fees keep getting higher. So, as I said, the USCIS is taking 6. This is dated. They're probably taking up to 9 months. And if you do premium processing, they will adjudicate it within 15 days. Spouses and unmarried children under 21 are eligible for H-4s under this process. And did you see the slide change? Yes, slide has changed. Okay, good. What is an H-1B? So an H-1B visa program allows, it's for they call professional workers. And what do they deem to be professional work? It is where the position, not what the individual has, that the position at minimum requires a bachelor's degree as entry into the work. That should seem very simple, right? Right. The problem is the way the USCIS analyzes this is by looking at the Department of Labor occupational codes and how those occupational codes deem that what the minimum entry is into the job. Those occupational codes are antiquated. I think when they came out, the only user interface was a mouse. They didn't anticipate smart, machines. They didn't anticipate all the things we're doing with our phones. So that can often become a challenge. The secret sauce, I always say to that, is two things. Number one, make sure the job description is not a generic job description, not what you use on your job postings, but something that is really tailored to the work that the individual will be doing. And then make sure you tie the individual's, the foreign nationals' education and background to demonstrate how they will be able to do that work. So the criteria is, what they look at, how they define a specialty occupation, is that the bachelor's degree is normally minimal entry into entry requirement for the position. It's not enough that you say that, you've got to demonstrate that. The degree is a requirement for the job is common in the industry, or the job is so complex or unique that it can only be performed by an individual with a degree. That's why those very specific job duties are important. That the employer normally requires a degree or its equivalent for the position. And that the nature of the duties are so specialized and complex that knowledge required to perform the duties are usually associated with the attainment of a bachelor's degree or higher. So these issues only come into play. We like to address this proactively, not reactively. So a couple of tips I'll tell you about proactive, assessment of all of this. We had a company, they're big in user interface. They received so many awards and other things, but they would not classify everyone that was doing user interface work as user interface work. Because they had some nuanced ways in which they made the distinction. They'd call them software developers. But actually, they were doing user interface work. Where that comes into play is when you file an H-1B, the USCIS will either approve it or they'll issue what's called a request for evidence. They want clarification. And so how do they obtain clarification? They will say, hey, this does not look like a specialty occupation. Demonstrate to us how it looks like a specialty occupation. And then we take this criteria and we try to gather evidence to show it only needs to meet one, but we try to meet all four. So if we want to demonstrate how a bachelor's degree is normally minimal entry, we'll look at articles. Not blogs, but like real articles that talk about how the occupation, that particular occupation is growing and changing and evolving. And so it's so complex that it requires a bachelor's degree as minimal entry. There is that antiquated book that sometimes is helpful. It's the Occupational Outlook Handbook. We will look to that, but more often than not, the IT jobs of today are not listed. We'll look at job posts for the positions that other companies have posted that are of similar size and doing similar work as the petitioner to demonstrate that it's normally requires a degree, that the industry normally requires a degree for that position. And then to demonstrate that the employer normally requires a degree for that position, we'll pull either employees' degrees. Sometimes, employers don't want to tell their employees. We'll pull their LinkedIn profiles and we'll pull payroll to show that the the employer typically requires a degree or its equivalent for entry into that position. So that example I was telling you before, where the employer kind of sometimes would call it a software engineer and sometimes a user interface, that's where that becomes a problem. Because when we're then going to show that the employer normally requires a degree and they show us varied job titles, well, that doesn't demonstrate the evidence for that particular position. So that's something to keep in mind on a proactive state when you're selecting the position. And the nature of the degrees are so complex. Like I said, we try to do that proactively so that we're addressing it on the front end and not the back end. Who pays the H-1B fees is a common question we see. Now, the employer are required to pay the USCIS fee, fraud prevention fee, and the employer fee. The premium processing and attorney's fees are optional, but the test is this. Because they're deemed business deductions for the employer, what you have to do is take whatever those fees are and subtract them from the salary that you're offering the employee and ensure that they're still above the prevailing wage. And I'll talk about that in a second, but just try to keep that, attorney's fees, premium processing fees, minus the wage offered must be greater than the prevailing wage. Just keep that in a little memo on the side, and I'll demonstrate what that means. How do we determine the wage level? So there is a DOL online wage library. Like I said, the library in terms of job titles is very limited, but it is what it is. It is geographic location specific. So it's where the work will be performed. And it's okay if folks are still utilizing, safe practices and their employees are working from home. But nevertheless, it is where the work is performed. Now, within that job title and that geographic location, the USCIS lists 4 wage levels. How do you determine which wage level? Well, this is part of our handbook. When we give you that, it is very clear as to how you determine the wage level. For example, wage level 1 is usually a beginner. There is a tremendous amount of oversight of the work, and they're working directly under the direction of someone very systematically. Under level 2, they have a little more exercise of judgment, but they're still working under the direction. And you can see that level 3, it's a progression where you're working and you've got more leeway into the work that you're performing. And then it depends on supervisory. Is the employee supervising any individuals? We cannot pick out the wage level, but we provide this to the clients and say, depending upon the type of work they're going to be doing, and you have to look at that within the scope of what are you offering your other employees with the same education and experience. When are the wage obligations triggered? So as an H-1B employer, whatever the wage you state on the I-129, you are required to pay that wage until the employee is terminated on an at least monthly basis. You can do it bi-monthly, you can do it, but at the minimum once a month, they must be paid the salary that's stated. And it can't be based on, unless you do part-time H-1B, which is permitted, on hours they work. If you list an annualized salary, it's got to be based on that annualized salary. Because if you don't say it's part-time work, the assumption it's full-time work. So the wage obligations are triggered. It's called the 30-day or 60-day rule. When an H-1B enters into employment, that means when they present themselves ready to work. they are required to, they are at that point compensable. So the employee must be paid when the employee is on non-productive status. There's no benching allowed anymore. The employees prorated on a monthly basis. The employer does not have to pay the employee for any personal leave. So if the employee is taking personal leave for their betterment, or, during that time, you're not required to pay them unless you pay other employees for their personal leave. So what you want to do is make sure that you document that if they're taking time off without pay. So you can put it in what I'm going to tell you is the public access file. The public access file is what every H-1B employer is required to maintain, and we'll be talking about that in just a second. So the 60-day trigger is when the employee is in the United States. You have to pay them 60 days within the time the H-1B petition is approved. The 30-day trigger is when the employee is outside the United States. So when the employee enters the United States, the wage obligations are triggered within 30 days. So that's important to know. Now, as we talked about the process, so you file the H-1B petition, the USCIS receives the case, they issue a receipt notice. I'm going to tell you ahead of time, they are incredibly slow at issuing receipt notices for regular processing. You're not going to get it anytime soon, but what you can do is look out for when you file an H-1B, they'll be filing fee checks. More likely than not, either the employer will provide the H-1B filing fee checks, or a lot of times employers will pay us and we will cut the checks. But if you look on back of the checks after it's cashed, you won't get a receipt notice, but you'll get a receipt number, which is always helpful to have. So either there'll be no request for evidence and the case is approved, or the USCIS will issue clarification and you have to submit a request for evidence and you just have to respond to it. During the Trump administration, RFEs were at an all-time high, request for evidence. And I have to say, we did an incredible job of not only reducing those for our clients, but also making sure that we were successful on the outcome. One of the key things employers need to look out for is when they terminate the employee. You remember those wage obligations I stated you're required to pay the employee at a minimum once a month? The only way that wage obligation is alleviated is either if the employee leaves your employment or upon termination. But one of the other things H-1B employers are required to do when they terminate the employee is offer the employee one-way airfare back to their home country. Okay, you have to make that offer. You don't have to give them cash for that offer. What you have to do is two things. One, you want to make sure that they acknowledge that they have notice of the termination. So either in your, exit interview or what have you, having them sign something that say they acknowledge that they have been terminated. Secondly, you want to say, if you want, we are required to offer you a one-way ticket to your home country. You don't have to send them to Hawaii or Paris, to their home country, unless they're from those places. Well, if it was Hawaii, it wouldn't be an issue at all, right? So one-way ticket to their home country, you can say, we'll have our travel people organize that for you. So only when they, and you want all this in writing as well. Because if you're ever audited, these are the two issues they look for in terms of ongoing wage obligations. So that's very important that you demonstrate that you made the offer, the employee never contacted you, and you can even do that through read receipt or some sort of email process where you've got confirmation that they did in fact receive the email, they read the email, they acknowledged it, and they stated that they did not need the return transportation. Most people won't, but if they do, you don't need to pay their family members, just the employee one-way ticket home. Now, what happens if the employee resigns? You're not required to, pay the one-way ticket, but you want to make sure that it's clear that the employee resigned, either through, email, or if they resigned without notice and without telling you, that you tried to make efforts to contact them and they did not respond. So you want to make, you want to have documentation that the employee did resign. Next, whether it's the termination or it's the resignation, in addition to maintaining the documents relating to how the employee departed from working for your company, you want to notify the USCIS that they're no longer working for you, and you want to withdraw the labor condition application. Once you do these 4 things, proof that the employee was either terminated or resigned. If the employee was terminated, proof that you offered the employee a one-way ticket back to their home country. Third, that you notified the USCIS that the employee is no longer working for you. And finally, that you withdrew the labor condition application. Then you no longer have ongoing wage obligations for the employee. So that's pretty important. The employee can travel while a transfer is pending. If they're changing status, if you have some folks that are changing status from F1 to H1B during this cap season, when they're changing from one non-immigrant classification to another non-immigrant classification, during its pendency, if they travel, that change of status is deemed abandoned. So you want them not to travel until it is approved. If they are extending their status or transferring, and they have an otherwise valid visa in their passport, then they will be able to return with a receipt notice of either the transfer or the receipt notice of the extension. But like I said, they do need an entry permit. They need that visa to come in. And I always suggest that they carry with them a current offer of employment, just to show that there is a valid job opportunity waiting for them. Lastly, we're going to talk about employer obligations under the public access file. When you file a labor condition application with the DOL, it triggers the requirement that the employer maintain a public access file. I ask all employers to keep this separate from the I-9 files, because if you were ever audited by the Department of Labor, you are required to provide them everything in the file. So you don't want to give them more than is absolutely necessary. So there is information on the employment's wage, compliance with the LCA. It's got to be created within 1 day of filing the labor condition application. It's got to be maintained for each employee, H-1B employee. And like I said, the files should be kept separate. So what's in the public access file? The public access file contains, a copy of the labor condition application. And then once the labor condition application is certified and the employer signs it, it would be the certified copy. When in our office, we send the public access file after we file the labor condition application. So it won't be executed. Sorry, it's been a long week, an executed labor condition application. And so we just ask you replace that with the executed labor condition application once it's been signed. The employee must get a copy of that labor condition application. So, you would have a document that says, and we provide that, the employee received a copy of the labor condition application. Put that in the file. There has to be documentation of what prevailing wage was used. So you keep a copy of we provide that if we do the work, a prevailing wage documentation to support the labor condition application. The other document that you need to supply is how do you calculate the actual wage? Doesn't have to be complicated. Remember, you are attesting that you're paying the higher of the prevailing wage, the wage outlined by the DOL for that level, that geographic location, and that position, or the actual wage, what you are paying workers within your organization with the same education and experience. So if the prevailing wage for that level is $60,000, but for people with the same education and experience in that position, if you are paying them $80,000, you have to pay them $80,000. So it's got to be the higher of either the prevailing wage or the actual wage. So they want to know how you calculate the actual wage. We've got a sample that we provide, but it's just basic stuff, years of experience, type of degree, special skills, things like that. You don't have to get down in the weeds and go into details. The other thing that employers are required to do is when we file the labor condition application, there is a notice requirement. You have to place that notice at the work site of the H-1B employee. It generally says, it doesn't say the employer's name, but it says we are looking to fill an H-1B position for a software engineer at the rate of $60,000 in this at this location. If there are any complaints, here's the DOL address. That notice must be posted for 10 business days, and you must, so after the 10 business days, it's got to be visible. They say it's usually where you place all your other employee notices. So in 2 conspicuous places. After the 10 business days, you take that down, you sign and attest to the dates that it was posted, and you place that in your public access file. Then there is the wage rate. So you're paying the employee X amount now. If there's any changes in the wages, then you would just update that wage rate document. And finally, as an H-1B employer, you're required to offer the H-1B employee the benefits that you're offering all your other employees. It can't be less. So there's an attestation for that as well. So all these are neatly put together and placed in a public access file. And there's a certain, if you terminate them, I think it's 1 year after the termination. And I think it's 3 years after the end of the term. And you would also keep in the public access file any requests where the employee is taking personal time, personal leave, or any variation to that. Okay. So travel, we've already covered. Amended petitions. The labor condition application, remember, is very specific to a geographic location. If you then place the employee at another location outside either the metropolitan statistical area or outside of commuter distance, then you are required to file an amended petition with the USCIS, because outside that MSA, it may trigger another wage level, because the wage is geographically specific. If it is within that period, if in that MSA, then you're not required. And if it's within commuting distance, and there's no clear cut, because what's commuting distance in New York will be very different from what's commuting distance in Richmond. A clear cut mileage for that. Then finally, it is okay if the employee has what is called, just infrequent visits. They may go to a client site 1 or 2 days. That's okay. But, if their location is change for a permanent, for a longer term, then you might have to look at whether you need an H1, a new amended H1B. You want to have someone within your facility. You want to have at least the folks talking about if DOL, and usually they don't, if DOL does come to your office for an audit, who should they contact? One thing that you need to know is if you've got an attorney, you can tell them that they are required to give you 3 days. So you can contact your attorney and your attorney will be in contact with them. And usually that works. Nowadays, no one's knocking on doors. Everyone's sending electronic notifications. So usually that is not a problem, but it is, the USCIS can also, on a separate note, conduct site visits to ensure the employee is actually working in the location specified on the I-129. So you do want to have a conversation internally about who the go-to immigration contact should be. I think we covered the I-9 rules. If you're filing a H-1B during this cap season for an F1 student who is currently working for you on optional practical training, their optional practical training may expire sometime this summer. But you filed an H-1B change of status petition prior to the expiration of their employment authorization document that allows them to work for you on optional practical training. So there is something called the cap gap. So as long as you file while the employment authorization document is valid, their change of status, they can continue working for you even if their employment authorization document expires in the summer, until their H-1B becomes valid October 1st. And for I-9 purposes, you would just put the receipt notice of the change of status to show that they meet that eligibility. And the timetable for this is one that we had especially with, during, you've got to make sure that you look at when there's a change of status, looking at when they'll be available for work, what the onboarding would be, and look at those timelines in lieu of the wage obligations that will be triggered. And so when you are looking at, I tell people that they need to have immigration strategies, just like they have tax strategies. What are the recruitment needs? Where do you see your organization? Where do they have growth and perhaps needs? What are the types of job titles and educational backgrounds? What's the time and duration of those resources? And what are the timing issues? And any structural changes that may impact your employees. If you're getting ready to go through a merger or an acquisition, it's important that you talk to your immigration legal counsel prior to that, so they can be part and parcel of that discussion. So you are proactively addressing any needs of your resources that are on some sort of non-immigrant status versus reactively. And then looking ahead at how many permanent resident applications you will be filing in a given year. We're going to do a separate webinar on the permanent resident status, but one of the things that is taking a long time that used to take 6 weeks is now taking 9 months is the prevailing wage. There are probably strategies that you could look at which would make you more attractive to recruiting candidates with the prevailing wage and the perm process, which I'll address in our next webinar on perms. So stay tuned for that. And then what's the current immigration landscape? What are the timeframes? What's that looking like? So, for example, now we know employment authorization documents are taking a really long time. There's no way to expedite them. There's no premium for them. So if you have a resource that's both on the adjustment of status and on either an H-1B or an L, and they say, oh, well, I'll get my employment authorization card, you should keep them on the non-immigrant status as well. Because with the non-immigrant status, you can leverage at least the 240-day rule by filing their extension, so there's no interruption of employment. The ability to do that with an employment authorization document is a lot more limited. And that way they have a safety net. So those are some tips that I have for HR resources. I know I have gone over a lot of things, and if you have any questions, we'll be happy to answer those questions now. No questions on Q&A or on chat? Well, then I thank you for participating, and we will, if you would like our H-1B employee handbook, please just email us at info@chelalaw.com, and we will be happy to provide that. We also have weekly webinars every week on topics that are, hot topics that are, probably something that your resources are looking into. This week, we talked about the whole interfiling changes and what are best practices for that. And we also talked about the new EB-5 reauthorization. So we've talked about Child Protective Act. We've talked about downgrading issues from EB-2 to EB-3, and now people are looking at EB-3 to EB-2. So if you haven't signed up for our webinars, please do. We'd love to have you be a part of that. I think you'll find it very useful. And we have a YouTube channel. So we encourage you to subscribe to our YouTube channel, because we always put up short little tidbits on, relocation or CSPA or other things that may be pertinent to the folks that are on the HR level, as well as foreign nationals who are going through the process. I thank you again for joining us today. I want to thank my team for helping me put this together. Subscribe to our webinars so you'll know when we're having our next. And if there's any topics you'd like us to cover, please email us at info@chelalaw.com. Have a great